Christensen v. Swenson. Swenson, a Burns employee, was assigned to guard Gate 4 at Geneva Steel Plant. Guards worked 8-hour continuous shifts with no scheduled breaks. However, employees were permitted to take 10 to 15-minute unscheduled lunch and restroom breaks. Gate 4 guards generally ate a bag lunch, but occasionally ordered takeout food from the sole restaurant within close physical proximity to Gate 4, the Frontier Cafe. The Frontier Cafe was located directly across the street from the Geneva plant, approximately 150 to 250 yards from Gate 4. The cafe's menu was posted near the telephone at Gate 4. Aside from vending machines located within a nearby Geneva office building, the Frontier Cafe provided the sole source of food accessible to Gate 4 guards within their breaks. Whether they brought their lunches or ordered from the cafe, Gate 4 guards were expected to eat at their posts. Shortly after 11 a.m. on the day of the accident, Swenson noticed a lull in the traffic at Gate 4 and decided to get a cup of soup from the Frontier Cafe. She placed a telephone order for the soup from Gate 4, then drove her automobile to the cafe. She intended to pick up the soup and return to Gate 4 to eat at her post. She expected the round trip to take approximately 10 to 15 minutes, as permitted by Burns' unscheduled break policy. On her return trip, however, she collided with plaintiff's motorcycle at a public intersection just outside Geneva's property. Several people were injured. When suit was brought against Swenson and Burns, claiming that Swenson had driven negligently, Burns moved for summary judgment on the ground that Swenson was not acting in the scope of her employment at the time of the accident. The trial court granted the motion, and the Court of Appeals affirmed. Summary judgment is appropriate when the record indicates that there is no genuine issue as to any material fact, and the moving party is entitled to judgment as a matter of law. We view all relevant facts and all inferences arising from those facts in the light most favorable to the party opposing the motion. Under the doctrine of respondeat superior, employers are vicariously liable for torts committed by employees while acting within the scope of their employment. Whether an employee is acting within the scope of her employment is ordinarily a question of fact. The question must be submitted to the jury whenever reasonable minds may differ as to whether the employee was at a certain time involved wholly or partly in the performance of the employer's business or within the scope of employment. However, when the employee's activity is so clearly within or outside the scope of the employment that reasonable minds cannot differ, the court may decide the issue as a matter of law. Berkner v. Salt Lake County, 771 P. 2nd, 1053, 1057, Utah, 1989. In Berkner, we stated that acts falling within the scope of employment are those acts which are so closely connected with what the servant is employed to do and so fairly and reasonably incidental to it that they may be regarded as methods, even though quite improper ones, of carrying out the objectives of employment. We articulated 3 criteria helpful in determining whether an employee is acting within or outside the scope of her employment. First, the employee's conduct must be of the general kind the employee is hired to perform. That is, the employee must be about the employer's business and the duties assigned by the employer, as opposed to being wholly involved in a personal endeavor. Second, the employee's conduct must occur substantially within the hours and ordinary spatial boundaries of the employment. Finally, the employee's conduct must be motivated, at least in part, by the purpose of serving the employer's interest. The Court of Appeals held that Swenson was not substantially within the ordinary spatial boundaries of her employment because the accident did not occur on Geneva property. Because the Court of Appeals concluded that Swenson failed to satisfy the second Berkner criterion, it did not address the first and third criteria. However, a review of the record indicates that reasonable minds could differ on all 3 criteria. Thus, to avoid a second summary judgment on remand, we address all three of the Berkner criteria. The first Berkner criterion requires that the employee's conduct be of the general kind the employee is hired to perform. That is, the employee must be about the employer's business and the duties assigned by the employer, as opposed to being wholly involved in a personal endeavor. Reasonable minds could differ as to whether Swensen was about Burns' business when she was involved in the traffic accident between Gate 4 and the Frontier Cafe. We base this conclusion on two disputed issues of material fact. First, Swensen claims that Burns employed her as a security guard to see and be seen on and around the Geneva plant. Thus, traveling the short distance to the Frontier Cafe in uniform arguably heightened the secure atmosphere that Burns sought to project. Burns, on the other hand, claims that Swensen was not hired to perform that function. Burns' position is supported by the deposition of another security guard who stated that he considered lunch trips to the Frontier Cafe to be entirely personal in nature. A second material issue of fact remains as to whether Burns tacitly sanctioned Gate 4 guards' practice of obtaining lunch from the Frontier Cafe. Burns expected its Gate 4 guards to work 8-hour continuous shifts and to remain at their posts as much as possible. However, because Burns also recognized that the guards must at times eat meals and use the restroom, the company permitted them to take 10 to 15-minute paid breaks. The record indicates that Burns was aware that its employees occasionally traveled to the Frontier Cafe during these unscheduled breaks, but never disciplined them for doing so. Indeed, Swensen asserts that a menu from the Frontier Cafe was posted in plain view at Gate 4. Thus, reasonable minds could differ as to whether Burns tacitly sanctioned, or at least contemplated, that its guards would satisfy their need for nourishment by obtaining meals from the Frontier Cafe. The second Berkner criterion states that the employee's conduct must occur substantially within the hours and ordinary spatial boundaries of the employment. It is undisputed that Swensen's actions occurred within the hours of her employment. She was at her post and in uniform when she decided to take advantage of a lull in plant traffic to eat lunch. With respect to spatial boundaries, we find that reasonable minds might differ as to whether Swensen was substantially within the ordinary spatial boundaries of her employment when traveling to and from the Frontier Cafe. While it is true that Swensen was not on Geneva property when the accident occurred, she is attempting to obtain lunch from a restaurant within the geographic area accessible during her 10 to 15-minute break. Given the other facts of this case, reasonable minds could differ as to whether Swensen's trip to the Frontier Cafe fell substantially within the ordinary spatial boundaries of her employment. Furthermore, Burns could not point to specific orders barring guards from leaving the facility in their own vehicles to go to the Frontier Cafe on break, although two managers opined that such behavior was prohibited. This dispute alone presents a genuine issue of material fact. If guards were expressly forbidden to drive to the Frontier Cafe to pick up lunch during their break, a jury could find that Swensen was substantially outside the ordinary spatial boundaries of her employment. If they were not so forbidden, a jury might find her to have been acting substantially within the ordinary spatial boundaries of her employment. Under the third criterion of the Berkner test, the employee's conduct must be motivated, at least in part, by the purpose of serving the employer's interest. Applying this criterion to the instant case poses the question of whether Swensen's trip to the Frontier Cafe was motivated, at least in part, by the purpose of serving Burns' interest. Reasonable minds might also differ on this question. First, two Burns managers admitted in their depositions that employee breaks benefit both the employee and the employer. Employees must occasionally eat meals and use the restroom, and employers receive the corresponding benefit of productive, satisfied employees. Reasonable minds could differ as to whether Swensen's particular break fell into this mutual benefit category. Second, given the continuous shift nature of the job and the comparatively brief breaks permitted, Burns' brake policy obviously placed a premium on speed and efficiency. Swensen claimed that traveling to the Frontier Cafe enabled her to obtain lunch within the allotted period and thus maximize the time spent at her post. In this respect, reasonable minds might conclude that Swensen's conduct was motivated, at least in part, by the purpose of serving Burns' interest. Evidence indicating that Swensen tried to save time on her lunch break by phoning her order ahead, driving instead of walking, and attempting to return immediately to her post is also relevant in this regard. In sum, we hold that reasonable minds could differ as to whether Swensen was acting within or outside the scope of her employment when she collided with the plaintiff's motorcycle. Thus, summary judgment is inappropriate. We reverse and remand for further proceedings.